4, 3, 2, 1.
Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning and welcome to the morning session of the Tennessee Court of Appeals. First of all, I want to thank both of you for agreeing to participate in this oral argument via Zoom technology. It's obviously not the way we've done things in the past, and it's been proven, at least in our experience, to work very well. But we appreciate you all participating in this. You're both familiar with how we do things in the Court of Appeals, and we'll follow that procedure throughout this proceeding. For instance, each side will receive 15 minutes to make its oral argument. If you're the appellant and you wish to reserve rebuttal time, I'm sure you've already reserved that with Mr. Hibner, and you'll be given that rebuttal time. But before we start, I want to introduce your panel for this morning. I have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. And again, want to thank you for participating in this. I want to thank Mr. Hibner and his staff for making this possible. I know they've worked with you to get all this done, as well as the AOC technology staff, who also does a wonderful job. So having said that, Mr. Hibner, if you'll call the case, we shall begin.
Reliant Bank versus Kelly D. Bush et al.
All right. We'll hear from the appellant.
Before I begin, I'd like to let you know that my wife is here with me, Kelly. So
yes, sir.
Wanted to make sure that you knew that she was here with me.
Yes, sir.
In what could easily be argued as the most famous trial ever in the history of mankind.
Dr. Bush, before you get started, you need to introduce yourself so we know who you are. We do know who you are, but it's all being recorded, so we want to make sure we get it all down.
Forgive me. I'm Dr. Byron Bush. I am a practicing dentist in the Nashville area for over 40 years. That was my wife, Kelly Bush, that was here beside me.
Right. Thank you.
Thank you then, Judge. In what could easily be argued as the most famous trial ever in the course of history of mankind is recorded in the 18th chapter of John, verse 37. Jesus was speaking to Pilate and said these words, "I have come to bear witness to the truth." Pilate then responded with the most important question of all time. And that question is, what is truth? There was no reply given, or at least none recorded. Then Pilate went out to the crowd and spoke the truth by stating, "I find in him no fault at all." And yet Jesus was then crucified. And so here we are 2,000 years later, and we are still struggling with what is truth. This is our fourth hearing before this court over the last 8 years. This is not a litigation process that we began, but was begun by Reliant Bank against us. In fact, our third appeal, Reliant Bank was the appellant. This is our fourth appeal. And we're still dealing and trying to get the difference between truth and whole truth. We are dealing with matters, subject matter, arising from two cases. It was stated as one, but it's Reliant v. Bush, 41461. And as is in the brief and in the motions and in the denial is also Bush v. Reliant, case number 44489. So it is two cases that come together. Judge Armstrong, it's a pleasure to have you here today. And Judge McGee, this is your first time to hear our arguments. And so I would just say welcome to you. Judge Stafford, this is your second time to hear us. In the same manner that Judge Frank Clement has heard us twice, you have heard us twice. And I know that you are trying to champion the field of ethics. You do your best to build public trust and confidence in the judicial system. And you heard us on our second appeal several years ago. And I want to say this very carefully, and I want to say it with absolute respect. My wife and I were very disappointed. And we were disappointed because there was evidence that was brought out and was revealed. And there is, once again, no mention in any of the opinions of this court. And I realize this is a sensitive matter, and it's one that I want to be very careful, and I want to do it with the absolute respect that you are due. And we're dealing with your colleagues, but that should not and that cannot influence your decision if your oath of office is to be honored. I want to begin with two questions that I would just like, if you would, for you to kind of keep in your mind in the background as I talk this morning. First question is, are good judges good if they see and hear bad judges doing bad and yet do nothing? The second question is, who has subject matter jurisdiction when there is fraud upon the court? In the matters between Reliant Bank and Bush's, there is a history of personal or territorial. So we have the personal and territorial jurisdiction because all of the parties live within Williamson County and function and practice in Williamson County. There's also a history of subject matter jurisdiction by the Williamson County Court. No party.
Dr. Bush, hold on just a second. I don't know about anybody else, but I was lost for about a minute there. Was anybody else lost?
Not then, but a little earlier, I was lost for maybe 15 seconds.
Judge McGee?
I was earlier, but not at that particular time.
Mr. Montgomery, could you hear everything?
Yes, Your Honor, I could.
Okay. I'm happy to go forward, and I'll look back at what you said since we're videoing everything, and but I just wanted you to know that for probably at least a minute, my screen went blank.
Do you recall how early it was in that process? And I know we were still.
You were saying you wanted us to keep two questions in mind, and then my screen went blank.
Okay. If you would like, I can. Did Judge Armstrong or Judge McGee hear those questions or what?
Yes, they heard everything.
You did hear
I
those?
apparently was the only one who went down.
Okay. Do you want me to repeat, or would you like me just to move forward?
Whatever you choose to do. I'm happy whatever way you want to go. I will listen to the oral argument again. So I'm good with that. If you want me to do that, or if you want to repeat.
I'll do it. I'm at your disposal, so I'll do it however you would like.
That's totally up to you, sir.
If you won't start the clock, then I'll repeat those questions, but that's your.
You can go ahead and repeat the questions, and then we'll start the clock.
All right, good enough. The two questions I'd like you to keep in mind is, are good judges good if they see and hear of bad judges doing bad and yet do nothing? That was question one. And question two was, in this particular case, who has subject matter jurisdiction when there is fraud upon the court? In the matters between Reliant Bank and Bush, there is a history of both personal and territorial jurisdiction because all parties and Reliant Bank exist and live and work in Williamson County. There is also a history of subject matter jurisdiction because all matters that have been heard by the Williamson County Chancery Court. Timeline. On December 4th, 2019, 1 year ago, Judge Deanna Johnson received our motion requesting an independent action by the court for fraud upon the court by Judge James G. Martin and appellate Judge Frank Clement. On the next day, on December 5th, I announced my candidacy for the U.S. Senate in the Republican primary, and the slogan that I used was, "It matters." And it matters about truth. Truth matters. Evidence matters. It matters who represents us in government, whether it's a police officer with his knee to the neck of a young man, or whether it is you, each of you sitting in your courtroom in your robes. On Friday the 15th, Judge Johnson filed her order of recusal and reassignment. And according to Judge Joseph Woodruff of the same Williamson County Chancery Court, she directed for hearing to its conclusion. Evidently, Judge Johnson believed that the subject matter heard in the Williamson County Chancery Court since 2012 was within the subject matter jurisdiction of the court. By the way, Judge Johnson does share an office with Judge Martin, and her recusal per Supreme Court Rule 10 was at least based in part upon her closeness in the case and to Judge Martin. But it is worth noting that if she had truly believed that Judge Martin was innocent of any deceit or fraud upon the court, she surely would have had no conflict or problem in finding him without fault. But for some reason, she did not feel comfortable in hearing the case. And I want to repeat, no party has ever brought up a motion to argue that the Williamson County Chancery Court does not have subject matter jurisdiction over these matters, except Judge Joseph Woodruff. Now, it was Judge Woodruff who dismissed the Bush filing without a motion from either party because of a lack of subject matter jurisdiction. He received the motion on or about Friday afternoon and then dismissed it before the court had even opened on Monday morning, December 18th, and he did so, and it was date stamped at 7:48 before the clerk's office opens. He did not mention the Bush, he did not mention the Bush filing by name, but simply referred to it as a complaint. He did not mention the judges entered into it by name. And while he claimed he did not have subject matter jurisdiction to hear the motion, he then took subject matter jurisdiction, to authorize Reliant Bank to begin collection proceedings against my wife and I for the same subject matter and for the same set of facts. He also took subject matter jurisdiction to downgrade or redefine our motion as a complaint. And let me read from his dismissal.
Well, let me ask you a question, Dr. Bush.
Yes, sir.
Tell me what it is that you intended to file, and tell me in which case you filed it.
At the initial time, it was for the first case, but then we did an amendment to that to include the second case. And that amendment was contained within the sworn affidavit, which he received a few days later.
Have these two cases been consolidated, or they continue to be two separate cases?
Well, the second case was dismissed because of prior suit pending several years ago, and they were not allowed to be consolidated by Judge Martin. He was very, they were not allowed to be consolidated. And so we have tried to bring them together. We were told initially that we could file later, and then when we filed later, we were told that can't do it. It's prior. Judge Martin said it was res judicata that came to the court, and the court said it was prior suit pending. So there's been a lot of variance in that.
So you filed it in the first case?
Initially, but a week later, we filed it again. I was just getting to that.
Okay.
Let me ask you this, Dr. Bush.
Yes, sir.
In your Rule 60 motion filing,
Yes, sir.
you alleged fraud, didn't you?
That is correct.
And then it was determined by this court that Rule 60 motion was untimely. Is that right?
Well, it was, but it was based upon the ruling by Judge Martin, who had omitted a key provision in the contract. There are two provisions. There was a provision in the note that said that was the only provision dealing with real estate. So if this loan is secured by real estate, that was left out by Judge Martin, and he compared it with someone that was simply borrowing money. And then he compared the security agreement, which says that the borrower's debt upon default shall be satisfied. So when Judge Johnson made that ruling, she did so based on the court's prior ruling that the note was non-recourse from the beginning, but that was done by an omission of Judge Martin. And so when we went back to try to not alter or amend, but when we tried to go back to Judge Johnson, she did not allow that. So it came to your court with the idea that the original contract was non-recourse, but that's not true. And this court then stated that you cannot make something ambiguous that is very clearly written. And the note contained the only provision for a real estate loan, and it said very clearly that if this loan is secured by real estate, then the security agreement shall define the terms of any default that occurs. That's what it says. Then you go to the security agreement and it very clearly says the borrower, upon default, the borrower's debt is satisfied. So that's where we are there. Any other questions?
Let me ask you this. If
Yes, sir.
in your first Rule 60 filing, it was determined that it was untimely,
Yes.
do you have any case authority for the position that you can then later under Rule 60 file an independent action, and because you filed it as an independent action, it can somehow be timely when your Rule 60 motion earlier was found to be untimely?
I believe I can. There is a difference between a motion for mistake and fraud under the provisions of that, and then if you go down lower in Rule 60, and if I have it here, let me see if I have it here. Then it talks about the court is not limited. The power of the court is not limited. There is a case, Bullock versus U.S., which is a 25-year-old case in which it was argued that there had been information withheld from the court as a result. And so there are no time limits when it comes to fraud upon the court. So a simple motion of a Rule 60 motion is one thing. But I also want to say this, in that if we had filed within a year the Rule 60 motion, it would have gone back before Judge Martin. So that would be like saying, okay, Judge Martin, I want you to rule on the fact that you have committed fraud against fraud yourself. And so that wouldn't work. And we had filed a Rule 60 motion in our countersuit, and we were told that, and Judge Martin ruled on it and dismissed it because he said there's a prior suit pending. It is out of his jurisdiction. So it was very strange that we would have to go to the person that has ruled with fraud, and we would have to make that case before him, and he would have to rule on that himself. But I do want to stress.
Well, just a second, Dr. Bush, you've used your time. Has he answered your question, Judge Armstrong?
He has.
All right. You've got your rebuttal time, Dr. Bush, but you've used your allotted time. We'll now hear from Mr. Montgomery as appellate, and you can then follow up with your rebuttal. Mr. Montgomery?
Good morning. May it please the court, my name is Steve Montgomery, and I'm representing Reliant Bank, the appellee in this appeal. This court should affirm the trial court's dismissal of the appellant's motion requesting independent action by the court for fraud upon the court. The trial court correctly determined that it did not have subject matter jurisdiction over the motion because the motion raises only claims of judicial misconduct. It's important to make this point from the beginning. The unsubstantiated allegations in the appellant's motion have absolutely no basis in fact and are not supported by the record. With that said, the appellants argue that Chancellor Martin intentionally omitted certain material facts from the findings of fact and conclusions of law that he issued after presiding over the bench trial of this case in 2014. This court considered and rejected that exact argument in the appellant's direct appeal of this case in 2016. In fact, in its opinion affirming the decision of the trial court, this court praised Chancellor Martin for preparing, quote, comprehensive and detailed findings which fully comply with Tennessee Rule of Civil Procedure 52.01. That does not stop the appellants from continuing to baselessly attack those findings and impugn Chancellor Martin's character for the past 5 years. The appellants also argue that
question, Mr. Montgomery, why does subject matter not exist here? Subject matter jurisdiction?
Because under the Harvey case we cited in our brief and under Tennessee Code 175301, exclusive jurisdiction for matters relating to allegations of misconduct by judges is vested within the Board of Judicial Conduct.
Well, I understand that argument, but what Dr. Bush seems to be saying is there is some fraud involved in this. If you get past who he alleges committed the fraud, it's still a fraud action. So why does the court not have subject matter jurisdiction of that?
Well, there's a distinction between the instant motion that's before the court that requests independent action by the court for fraud upon the court. And that's what Judge Woodruff held the trial court has no subject matter jurisdiction over. And then there's the rest of the case. It's clear the trial court has subject matter jurisdiction over the rest of the case, because this is it's a breach of contract foreclosure deficiency case. So that's the distinction we would make. And I'd point out, Your Honor, that
I'm not sure following your distinction that the question of whether or not a court has subject matter jurisdiction is determined by who the alleged perpetrators of the fraud may be.
Well, I think when it's a claim that there is misconduct by a judge, fraud, any type of judicial misconduct, then I think those are exclusively within the province of the Board of Judicial Conduct.
I believe that if you're looking at sanctioning a judge or determining whether that in fact happened, yes, that would be accurate. But the real question is, there are allegations that fraud has been perpetrated in this case. I'm still at a loss as to why the court lacks subject matter jurisdiction to consider that allegation.
Well, I'll assume, Your Honor, for the basis of argument that it did. There is nothing in this record that would state a claim for fraud by Reliant Bank, by
That's
Chancellor
not why
Martin.
the trial court dismissed the case, though.
That's correct, Your Honor. The trial court dismissed it on the basis of lack of subject matter jurisdiction.
Let me ask you, Mr. Montgomery, was there any other basis that the court could have used in dismissing that lawsuit?
Yes, Your Honor, there was. The appellants have not come close to meeting the extraordinarily high burden that they would have to satisfy to state a claim for fraud and overturn the non-appealable judgment of the trial court. The Tennessee Supreme Court has stated that resort to an independent action under Rule 60.02 may be had only rarely and under unusual and exceptional circumstances.
Well, let me stop you there before you go any further and ask you the question that Judge Armstrong asked Dr. Bush, and that is, can you, after you have filed a Rule 60 motion alleging the same thing, turn around and file an independent action? Is that permissible?
No, Your Honor, it is not. That is the furlough case that we cited in our brief. It's from the Tennessee Supreme Court in 2013. Its citation is 397 Southwest 3rd 114. And it clearly says that if you file a Rule 60.02 motion, you may not also file a separate independent action. I think that's
do that, or at the same time?
I'm sorry, Your Honor, I couldn't hear your question.
I apologize. In the furlough case, when was the independent action filed? Was it filed at the same time, or was it filed at subsequent to the determination of the Rule 60 motion?
I believe it was subsequent to, Your Honor.
Okay, thank you.
As we have in this case.
All right, thank you.
But even if the court could get past that procedural deficiency, the appellants would not be entitled to relief. An independent action to set aside a judgment requires proof of extrinsic as opposed to intrinsic fraud. Intrinsic fraud encompasses matters that occur within the subject matter of the litigation, like falsified evidence, forged documents, or perjured testimony. Intrinsic fraud must be proved at trial, on direct appeal, or through a timely filed Rule 60.02 motion. If it is not, no further remedies available. The appellants here allege only intrinsic fraud. They claim that Chancellor Martin and Judge Clement committed fraud within the course of the litigation by not making certain findings and conclusions that the appellants believe they should have. To be clear, this is not fraud of any sort, and the court will not find support for these claims of the appellants in the record. This is nothing more than a pretext for the appellants to once again seek to overturn the judgment of the trial court that is final and not subject to further appellate review. The appellates cannot and do not identify any facts or circumstances outside the scope of this lawsuit that possibly could constitute extrinsic fraud. Thus, the trial court was correct to deny their motion for independent action. Today, the court has before it the appellant's fourth attempt to relitigate the 4-day trial that the trial court conducted in 2014.
Let me ask you another question, Mr. Montgomery. Are the allegations any different in this independent action or the action that's currently pending before the court and the Rule 60 allegations? Are they the same, or is there something different?
Well, in the Rule 60.02 motion, the allegation was that Reliant Bank committed fraud by through some of its testimony in the trial court. And I would point out that the trial court found, and I'm looking for the quote. The quote was, "The Bushes have not averred facts which could constitute fraud under Rule 60.02 parentheses 2." And this court, of course, reversed the grant of partial relief to the appellants and reinstated the original judgment of the trial court. The allegations in this motion are different in the sense that there's still an allegation that Reliant Bank committed fraud, but there's an allegation now that Chancellor Martin and Judge Clement committed fraud by not finding that Reliant Bank committed fraud.
Okay, thank you.
Sure. In addition to the direct appeal, as alluded to, the appellants filed a second suit against Reliant Bank in the trial court while the direct appeal was pending. In that suit, they sought to bring claims that could have been brought in as counterclaims in the first suit. Now, that second suit had no reasonable chance of success given the pending prior suit between the same parties that involved the same transactions. And of course, the trial court did dismiss that second lawsuit, and this court affirmed. As discussed, the appellants then filed the Rule 60.02 motion. That motion had no reasonable chance of success because it was not filed within 1 year of the trial court's judgment. Now, again, the court has before it the appellant's instant motion for an independent action in which they again seek to have the trial court's findings of fact and conclusions of law set aside. We would respectfully submit that in light of this motion's numerous procedural and substantive deficiencies, this appeal has no reasonable chance of success. All these pleadings have different labels, but in each of them, the appellants ultimately seek the same relief. They ask this court either to ignore the findings and conclusions that were made by Chancellor Martin and issue different ones, or to throw out Chancellor Martin's findings and conclusions altogether and order a new trial. But the time for that has long since passed. Appellants have had numerous opportunities to present evidence that could support reversing the trial court's judgment. Ultimately, they've been unsuccessful in every attempt. The time has come for this litigation to end permanently. Of course, every time the appellants bring before the court a pleading that has no reasonable chance of success, Reliant Bank is forced to incur attorney's fees and expenses. So Reliant Bank asks the court for two things. First, that this court remand to the trial court with instructions to determine the amount of attorney's fees and expenses to be awarded to Reliant Bank for defending against this motion. The promissory note that the appellant signed is in the record at volume 1, page 6. Paragraph 20 of that note provides, quote, "In the event of default, I, meaning the appellants, agree to pay all reasonable costs you, meaning Reliant Bank, incur to collect on this loan, including attorney's fees, court costs, and legal expenses." End quote. In the appeal of the grant of partial relief under Rule 60.02, this court held that paragraph 20 of the promissory note mandates an award of attorney's fees and expenses incurred on appeal.
Well, let me ask you, Mr. Montgomery, in Bush 2, the Court of Appeals did not award appellate attorney fees, did it?
I do not believe it did, Your Honor.
Okay.
Second, we would ask the court should remand to the trial court with instructions to impose a pre-filing screening mechanism, as in the Hooker versus Sundquist case that we cited in our brief, in order to prevent future frivolous filings by the appellants. The appellants have given every indication that they fully intend to continue to file pleadings in this case that have no reasonable chance of success. In their principal brief at page 5, the appellants say, quote, "We are here again for the fourth time because the courts/judges have not in any way openly acknowledged these material facts alleged/admitted by Reliant Bank senior officers that are incriminating, that would change the outcome. As a result, and in the presence of FUTC, meaning fraud upon the court, the order is never final but void," end quote. 3 pages later, the appellants make clear what they really want when they say, quote, "Therefore, this appeal now includes a motion for new trial because it matters," end quote. This is a non-subtle way of saying that the appellants intend to keep filing and keep appealing ad infinitum. This court is empowered to remand this case to the trial court with instructions to require that future filings by the appellant that relate to any claim that was or could have been raised in this case should be referred to automatically to a special master for review. The special master would then make a report and recommendation to the presiding judge regarding whether the filing is legally frivolous or duplicative. If the special master and presiding judge concur that the filing should be dismissed, it would be dismissed without prejudice, without requiring a response from Reliant Bank. Again, Reliant Bank filed a one-count complaint against the appellants for breach of contract in March 2013. The trial of this case took place in August and September of 2014. In the intervening 6 years since the trial court issued its ruling, the appellants have exhausted all available remedies for seeking appellate review of the trial court's judgment. It is time for this litigation to end finally and forever. We would respectfully request that this court affirm the decision of the trial court and remand to the trial court with instruction to determine the amount of attorney's fees and expenses to be awarded to Reliant Bank and to implement a Hooker versus Sundquist pre-filing screening mechanism. That concludes my argument, Your Honors. I would be happy to entertain any other questions from the court, but otherwise I would yield the rest of my time.
Seeing none, we thank you for your argument, and we will hear the rebuttal from Dr. Bush.
Can you hear me?
Yes.
All right. I don't know where to begin.
Well, let me ask you this, Dr. Bush, before you start. When you filed your first Rule 60 motion,
Yes, sir.
were you aware of this alleged fraud on the part of the court and the Court of Appeals?
I was becoming aware of it, and yet we were with hopes that when the court would hear the information, that it would then be repeated.
Well, the decision by Judge Martin and the opinion written by Judge Clement occurred prior to your filing your first Rule 60, didn't it?
I'm not sure I follow you.
Judge Martin's decision, Judge Clement's opinion occurred prior to your filing your first Rule 60. They've taken no further actions in this case since those decisions, have they?
The first Rule 60 was bringing up evidence that had been left out of all rulings by the court that concerned Reliant Bank. This fraud upon the court is bringing up evidence given that here was the evidence in the trial. Here was the evidence given in the transcript. Why is it not repeated in the opinion, even though we have filed motions to amend? Reliant Bank, their own testimony says that their contract was a mistake. Their mistake, in no way our mistake, and yet we've been held responsible for that. But if you read the opinions of the court, you'll find none of that anywhere. You won't find that they knew about it for 4 years. You won't find that they didn't tell us.
Let me ask you, what prevented you in your first Rule 60 from making those allegations?
We did, but they were never repeated. That's the point. If you read the opinion of the court, you'll never read any of this evidence. It's been squashed, it's been hidden, it's been slid under the rug. And that now becomes a court issue. And if you read the Board of Judicial Conduct, it is found in TCA 17.5-11 through 17.5-311. The Board of Judicial Conduct does not once in any of these, and I've read every word, mention fraud upon the court. Fraud upon the court is distinctly different. It involves the court itself. It involves where court officials, officers of the court, have withheld evidence and kept it from the honorable court. And so that is the difference. And our first filing of the Rule 60, which is the only one that speaks of fraud upon the court, that was the motion dealing with fraud by Reliant Bank. This one is dealing with it on the part of Judge Martin and Judge Clement, who heard it twice. So they're two totally different things. And it was dismissed, never heard. Go back and read the opinions. You will not hear about Reliant Bank testifying that it was their contract. The reason we were in court was their mistake. You will not hear about the fact that they knew about it for 4 years. You will not hear about the fact that they did not tell us and would not have told us if we had even asked. And you will not find out that their documents were altered. You will not see any of that. Why? It's two different cases. So the first Rule 60 was fraud by Reliant Bank. The second Rule 60 is where it has been squelched. The evidence has been swept under the rug by Judge Martin and Judge Clement, who has heard it twice, and it has never been revealed. So when you read case law of Reliant and Bush, both cases, you will never see any of that evidence. Where did it go?
All right,
Why is it not
Dr.
in there?
Bush, you've used your time.
Thank you.
All right, thank you, gentlemen, for your argument. We will attempt to get you an opinion as quickly as possible. We appreciate you participating in this argument by Zoom. Mr. Hibner, if you will, recess us until the call of the next case.
This honorable court is now in recess until